Okay, Mr. Woodcock, are you able to hear me okay?
Yes.
Okay, great. We're on the record now in People versus Rachel Gann. This is case number 236641. The record should reflect Ms. Gann is connected by video. If I could have both counsel put your appearances on.
Good afternoon, Assistant Attorney General Emmanuel Otsego, on behalf of the people.
Larry Brown on behalf of Ms. Gann.
Okay, this is set for a scheduling conference in this case today. Looks like it's Ms. Gann's first appearance before circuit court. Mr. Brown, can you tell me where we're at with this file?
I can, Your Honor. Again, this is our first appearance. I have spoken with Ms. Gann. At this time, she was currently seeking employment. She was homeless for a while. She is fairly confident she is going to be able to gain some employment. There is a multi-tiered plea offer, dependent upon how much she may be able to pay down some of the arrearages. We are going to, and again, this is tax season. I don't know if she can file, maybe get some tax credits or something like that, and get some money in, but we are going to ask for an adjournment. We'd like 90 days. I know that's a long time for the court, but whatever length of time we can get that the court will allow in order for her to try to pay some of this down.
All right, thank you. Mr. Woodcock, do the people take any position on that request?
Yes, Your Honor. People would oppose a 90-day adjournment. Ms. Gann hasn't made any payment since September 2021. So I don't believe that a 90-day adjournment is going to be beneficial to getting this case resolved.
Okay. All right, since this is Ms. Gann's first appearance before the circuit court, I don't have a problem with an adjournment, particularly for the reasons indicated by Mr. Brown. But I agree with Mr. Woodcock. I think 90 days is a little excessive. So the court will set this for a status conference plea hearing in 60 days. That'll give Ms. Gann an opportunity to hopefully make some payments, and then Mr. Brown give you an opportunity to further negotiate with Mr. Woodcock over a resolution. But if we don't have a resolution at that 60-day mark, then the court would get it set on the trial calendar. Mr. Woodcock, other than what you've already stated in terms of objecting to a lengthy adjournment, any additional objections to that plan going forward?
No, Your Honor.
Mr. Brown?
No, Your Honor. Thank you.
Okay. Mr. Woodcock, anything further that we needed to address from the side of the people?
Not on this matter, Your Honor. Thank you.
Thank you, Mr. Brown.
Nothing further. Thank you.
Okay. Ms. Gann, just make sure that you stay in touch with Mr. Brown. That's going to be really important so that you're ready to proceed at the next hearing, as well as so that you can communicate with him whether you've been able to make payments, and if so, in what amounts, and help him communicate with the Attorney General's office. So it's very important that you stay in touch with Mr. Brown. Other than that, the court will send out notice of the date and time of that next hearing. And all parties in this case are free to disconnect at this time.
Thank you.
Okay, do we have Ms. Norling here? Okay, Ms. Norling, if you can come right up to the podium, please. And we're on the record in People versus Norling, case number 236645. The record should reflect Ms. Norling's present here in the courtroom today. If I could have counsel put your appearances on in this file.
Hannah Booker, appearing on behalf of people.
Larry Brown on behalf of Ms. Norling.
Mr. Brown, how did we want to proceed today?
Your Honor, this is our first appearance in circuit court. This was bound over at the end of October. I did have a conversation with Ms. Norling. I sent her her discovery packet. Apparently she did not get it, so I need to resend that to her. And there is also some information that she states she can provide me within the next couple of weeks or so that I'm waiting on. So I would request 30-day adjournment.
Ms. Bruker, has there been a plea offer made in this case?
There is, Your Honor. The plea offers that if she pleads to count 1, count two would be dismissed. In addition, there is a restitution request for $186.
Okay. All right, so Ms. Norling, the court's gonna set this for a hearing in about 30 days. The next time we're back in court, I'll need you to have made a decision about whether you want to accept that plea offer that Ms. Kruger just stated or not. If you do, then we'll go forward with the plea hearing. If not, then the court will set this for trial, okay? So it's important that you stay in touch with Mr. Brown over the next 30 days so that you're prepared to make that decision at the next hearing, all right? Ms. Kruger, anything further we need to address in this file for your side?
No, Your Honor.
Mr. Brown?
No, Your Honor. Thank you.
Ms. Norling, did you have any questions?
No,
Thank you, that's all for
thank you.
Okay, next hearing is set at 1:45 for Mr. Hoffman. So we'll take a short recess and we'll come back on the record at 1:45.
Or us.
on the record in People versus Travis French, case number 236475. The record should reflect Mr. French is present here in the courtroom today. If I could have counsel put your appearances on.
And a worker appearing on behalf of people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. French.
This is the date and time set for sentencing in this matter. Mr. French, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes.
Mr. Trush, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Brooker, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, the recommendation is 36 to 60 months. I've reviewed the report. It appears in the past, Mr. French did have a prior controlled substances conviction that was at first handled under HIDA, and then eventually that was revoked. Given the nature of the crime and the circumstances, I would ask the court to follow DOC's recommendation at the lower end of the guidelines. I'd also ask the court to order the restitution to sane as well.
Mr. Trush?
Thank you, Your Honor. This is a somewhat unique situation in that, I mean, we have a person who presents with their first felony conviction here. One felony, 4 misdemeanors, so relatively minor prior history compared to what the guidelines range is. And obviously that guidelines range is what it is because the offenses that he pled to are B-grade felonies. It would seem appropriate to me, given the circumstances, to follow the recommendation from MDOC to the lowest end of the guidelines. I would ask the court to consider 36 months. That would render him eligible for potentially to be treated in the boot camp program, which he's hopeful he'll be able to do. And that would seem appropriate given the situations. I don't think the court has to look hard at this to recognize Travis has a substance abuse issue. To his credit, he did do rehab in the time between when the other charge was taken care of and the sentencing here. So I do think he has a little bit of the jump start on the recovery process, but I think that boot camp would give him good structure to be able to reintegrate. And I think that would be appropriate given his lack of prior history. So we'd ask the court to follow that recommendation to sentence him at the lower end of the guidelines. And obviously we'd hope for 36 months so he's at least eligible for the boot camp program.
Thank you. Mr. French, was there anything that you wanted to say today?
No, Your Honor, just sorry that like my choices led to me being here in front of all you guys today, and I'm trying to change my ways around, like you said earlier, with going into rehab and stuff at Bear River and completing that program. I completed 38 days and got my certification there, and just would like to apologize to the people in the court for my actions.
Okay, I did review the report prior to the hearing today, so I'm familiar with the circumstances that resulted in the charges here. It looks like there were multiple sales to confidential informants throughout a period of a couple months there in the fall of 2022. And looking at your background, there's also a lot of information in that report about your background and circumstances as well. And certainly your own substance abuse issues are a factor in that. Mr. Trush is right. I mean, you don't have a real lengthy criminal history generally, certainly not a lengthy felony history, but this particular charge has gotten you into some pretty hot water really quick. Given your age, given the circumstances here, I do think a sentence as recommended is appropriate. I think giving you an opportunity to be eligible for the boot camp program, although I know you've been on probation a couple of times before, that might be a different experience that combined with the treatment program that you participated in may help you going forward. So the court is going to follow the recommendation. I do think it's appropriate. As to both counts in this case, the court is going to sentence you to 36 months to 20 years in the Michigan Department of Corrections. You do have credit for 41 days served as the each. court is going to order restitution in the amount of $500 that's payable to the Otsego County Clerk to be dispersed to Straits Area Narcotics. Traffic victims assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and $136 state cost. You do have the ability to seek an appeal of this sentence. Mr. Krusch, can you provide those appellate rights to Mr. French, please?
Yes.
There.
Okay.
And for the record, the court will make both sentences to run concurrent to each other.
Okay, so it's set for business, so,
Yeah, there's something that is.
okay, thank you.
We've already discussed this.
Thank you.
People versus Hoffman, case number 236599. Mr. Hoffman, if you come right up to the podium there. Record should reflect Mr. Hoffman's presence here in the courtroom today. If I could have the counsel put your appearances on.
You have a first name and tax people.
Larry Brown on behalf of Mr. Huffman.
Mr. Brown, can you tell me where things are at with regard to this file today?
Yes, Your Honor. This case is still relatively new. It looks like it was found over maybe 2 months ago. Mr. Huffman advised me that he is currently working on a job in which he should be paid for that a substantial amount of money here within the next week or so. We're going to request one more adjournment in this matter.
This is it.
What?
I said, this is it too.
Yes, and I did advise him that it's still getting a little bit late here, so if the court would grant this one last adjournment, I did advise him that it is not likely to keep adjourning out, and by the next court hearing, he was going to have to make a decision. There is a plea offer in this matter that if he can pay the restitution, I believe it is for an attempt, which would be a misdemeanor.
That's correct.
Okay. All right, and what is the amount of the rest?
Which 3,000 or something?
I believe it's $3,085.44.
Correct.
Okay.
Okay. All right, Ms. Brooker, do the people take any position?
I have no objection to that.
All right, this is the kind of case, Mr. Huffman, where a big component of this is getting the victim here their money back. So I'm willing to give you a little bit more leeway in order to do that. So the court will adjourn this for 30 days. However, I think we're all on the same page here that if it doesn't happen, if it doesn't happen by then
It will happen before then.
okay.
Now, do I make that out to the prosecutor's office?
That's a
This
question. for
cashier's
Mr.
check
Yes,
to the prosecutor's office?
yes, and then we'll remit it to the victim.
Okay, thank you.
All right, otherwise, just make sure that you stay in touch with Mr. Brown.
If we have been staying in touch. Thanks.
Good. Mr. Brown, anything further today?
No, Your Honor, thank you.
Ms. Kruger?
No, Your Honor.
Okay, thank you. That's all for today.
Thank you.
Judge, are we gonna do anything with the show costs?
I'll dismiss that since Mr. Huffman.
Okay.
Here today. All right, sir, can you tell me your name there, please?
James DeMacy.
All right, we'll go on the record in People versus Denise. This is case number 236605. The record should reflect Mr. DeMacy's present today by video from Department of Corrections. If I could have counsel put your appearances on.
Amanda Berger appearing on behalf of the people.
Larry Brown on behalf of Mr. Mason.
All right, so Mr. Brown, I'm in receipt of a police report. Do we have a plea agreement in this case?
Yes, Your Honor. Sorry, I'm pulling that out. It looks like it would be pleading to count one for a dismissal of count two, as well as an agreement not to issue any more charges.
Mr. DeMacy, do you have to leave that room there? It looks like there's some kind of alarm going off.
I think they're doing testing. They've been doing it for the last like 5 minutes.
Okay, all right.
It goes on and
Thank
goes
you.
off.
Okay. If you have trouble hearing what we're doing at any point, just raise your hand or let me know and I can have things repeated for you, okay?
Thank you, Your Honor.
All right, Ms. Bruker, is that a correct statement of the plea offer?
The habituals would be dismissed as well, Your Honor, so it would be basically count one.
That's correct, Judge.
All right, and this is a no contest plea?
Yes, Your Honor.
What's the basis of the no contest plea?
I have had conversations with Mr. DeMacy, the most recent of which I had a fairly lengthy phone call with him back on the 4th. He is essentially stating that he really just does not remember any of this.
All right, Ms. Bruker, do the people have any objection to a no contest plea on the basis of lack of memory?
No, Your Honor.
Okay. All right, Mr. DeMacy, have you had a chance to talk to Mr. Brown about this plea agreement?
Yes, I have, Your Honor.
And is that how you want to proceed today?
Yes, Your Honor.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. And Mr. Brown, is Mr. DeMacy subject to any conditions that are going to be affected by the plea today?
I do not believe so.
Mr. DeMacy, are you currently on any kind of probation or parole?
No, I'm still in the prison.
Were you on parole at the time that this incident occurred back in, it looks like between October and December of 2022?
I was on probation, Your Honor.
You were on probation? Okay. Is that probation, are you still subject to that probation now?
Not that I'm aware of, Your Honor.
Okay. All right. Ms. Bruker or Mr. Brown, are either of you aware of any potential consecutive sentencing sanctions?
I don't think so.
I am not either.
Okay. All right, and Mr. DeMacy, you understand that the maximum possible penalty you could face by pleading no contest to count one, which is aggravated possession of child sexually abusive material, is up to 10 years and or a $50,000 fine. Do you understand that?
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Okay, your attorney indicated that you were going to plead no contest. Is that how you want to plead?
Yes.
Okay. Right now you have certain rights. I'm going to go through all your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand that you have all those rights.
Yes, I do, Your Honor.
And you understand that even though this is a no contest plea, you're still giving up and waiving all of those rights, including the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've talked about on the record here today?
No, Your Honor.
Is it your own free choice to plead no contest?
Yes, Your Honor.
All right, I have a copy of a Michigan Department of State Police Incident Report number 89-23, as well as the affidavit of probable cause. Ms. Bruker, have you reviewed those documents?
Yes, Your Honor.
Do you agree that those would provide a factual basis?
Yes, Your Honor.
And do you have any objection to the court using those and admitting those as a court exhibit as the factual basis?
No, Your Honor.
Mr. Brown, have you reviewed those as well?
I have. I believe they are sufficient as an actual basis.
Do you have any objection to the court entering that as an exhibit as the factual basis?
No, Your Honor.
The court has reviewed court exhibit 1. The court is going to mark those documents as court exhibit 1 and admit those to the file. Ms. Koch, Ms. Koch, that's tomorrow. Ms. Bruker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Brown, are you?
I am not, Your Honor, and I also believe that the court has complied with statute court rule for the taking of pleas.
Ms. Bruker, are the people satisfied the court has complied with statute court rule in taking in this plea?
Yes, Your Honor.
All right, Mr. DeMacy, the court finds that your plea is knowing and voluntary. The court has reviewed court exhibit 1. I find that it does establish a factual basis to support a finding that you are guilty of count 1 in this case. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Mr. DeMacy, between now and that date, you'll be contacted by somebody from Department of Corrections for a pre-sentence report. Mr. DeMacy, you do have the right to have that sentencing hearing in person. If you wanted to exercise that right, the court would sign an order to have you transported here to Otsego County so that you could be here in the courtroom during that sentencing hearing. You can waive that right and we can have that hearing by video as we're doing today. You know how you'd like to proceed in that regard?
Video is fine, Your Honor.
All right, the record should reflect Mr. DeMacy has waived his right to an in-person sentencing. We'll set this matter for Zoom sentencing. Ms. Bruker, I'll just ask that your office prepare a writ for Mr. DeMacy to appear by video. Ms. Bruker, anything further we need to address on this file today?
No, Your Honor.
Mr. Brown?
No, Your Honor, thank you.
Mr. DeMacy, did you have any questions at all?
Yeah, will I be receiving all this paperwork too?
Yes, you'll be contacted again by the department for a pre-sentence report, and you'll have an opportunity to review that and go through it with your attorney before the sentencing hearing.
All right, well, thank you, Your Honor.
Okay, that's all for today. The court's going to disconnect at this time.
All right, thank you.
Next hearing set for 2:30.
Yeah, I apologize. I'm gonna ask for a moment to speak to Ms. Gold and put it on the record on that. I don't know if the Attorney General is already here in the other matter.
Since that's a small space.
Yeah.
Is Eric Paul present? Oh. We're on the record in People versus Eric Ball. This is case number 236597. The record should reflect Mr. Ball is present here in the courtroom with his counsel, Mr. Trush. We have Mr. Oda Coker present by video on behalf of the people. Mr. Trush, can you tell me where this file is at today?
Yes, Your Honor. I guess so that there's two ways I think that I would propose that the court could proceed. I think, frankly, that we're headed right now on a trial track in regards to this matter. This is a very curious case. I've been provided information from my client, which is frankly a signed order from Your Honor in the front of the court file that purports to extinguish his child support obligations. I think that I need to look closely and get the rest of that front of the court file to find out if there's any other actions that took place after that. But certainly the order on its face appears to extinguish his child support obligation. I don't know if that was actually the intention of the order of the court on that date, but I certainly can understand how my client could interpret it that way. And if there's not any clarifying order after that, I think it very likely presents him with a defense. But this information has come into me recently. I think I need to get the rest of that front of the court file to be able to make a reasonable representation to him on whether or not he should have a trial or not. And I also need to be able to discuss that information with the Attorney General in regards to whether or not they intend to proceed or not, or what they think that order means. Because obviously not everyone will necessarily interpret that order the same.
Okay. All right. Thank you. Mr. Awuda Coker, any input from your side?
Well, I don't know what order council's referring to, so I don't have any, I guess, comment on that. I did send an email. I believe Mr. Ball posted a $14,350 bond. I did send the email to council about getting that bond applied to his support case. I don't know his position on that, but I guess at this point, I think from what I heard just now that Mr. Ball wants a trial to be set, at least at this time.
All right. I think Mr. Trush and Mr. Awuda Coker, what I'd like to do is just get this on the trial calendar. It's going to be some time before the court will be able to, get an actual trial date, but at least it's on the list. And we have some dates going forward with an end date in mind at some point. So Mr. Awuda Coker, if we were going to try this, is this something that we could try in one day?
I believe so, Your Honor.
Mr. Trush?
I would tend to agree, Your Honor.
Okay. And Mr. Trush, is this jury trial?
Yes.
Okay. So the court will set this for a one-day jury trial. We'll get it on the list for that. Then the court will set it for a final status conference. Excuse me. Final status conference prior to that trial date. That'll be the plea cutoff. If the parties reach a resolution and want to have this resolved sooner than that, just notify the court and we can get it on for hearing prior to that. But otherwise, like I said, we'll get it on the trial calendar. So we have those dates out there for a final resolution. Mr. Awuda Coker, any other dates I can address for your side today?
No other dates, Your Honor. I guess while I have Mr. Trush here, I'd just like to inquire if he's willing to have the bond assigned to the support case or not.
Yes, we would be agreeable to that, Your Honor.
Okay, so Mr. Awuda Coker, they're indicating yes, they don't have an objection to that.
Okay, and just to confirm, Your Honor, can the court tell me that bond is 14,350?
Yep, just one second.
I think it's 14,530 is what my client's telling me.
Okay,
14,530.
Yeah, 14,530 is the number that we have of the court record.
okay. Thank you, Your Honor. I'll also prepare an order and submit it to the court.
Okay, that's all I have for today. Mr. Awuda Coker, you're free to disconnect at this
All
time.
right. Thank you.
And Mr. Awuda Coker, I'll send that order over to you
Okay.
and more in front of the court file once I get all that information.
Okay, sounds good. Thank you.
Thank you.
All right, and Mr. Truce, you said you need a moment with Ms. Bowen.
I do, Your Honor.
Okay, just let the court officer know when you're ready to proceed. Okay, run the record in People versus Amanda Bowen, case number 236644. If I could have counsel put your appearances on.
Hannah Berger, appearing on behalf of People.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Bowen.
Thank you. Mr. Trush, how did we want to proceed on this file today?
Thank you, Your Honor. We do have a resolution for the court. Ms. Bowen, we plead to count 1 and count 3. So that would be possession of methamphetamine and possession of an analog. In exchange for that, count 2 would be dismissed. We would indicate, again, while it's not part of the plea agreement, Ms. Bowen is eligible for treatment under 7411. And we would be seeking that treatment for her, but again, it's not part of that plea agreement.
Okay. Ms. Brucker, is that a correct statement of the plea offer?
Yes, Your Honor.
Ms. Bowen, have you had a chance to talk to Mr. Trush about this plea?
Yes, Your Honor.
Okay, is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please?
I'm sorry, just to be fair and clear to everyone, there's also an agreement that the weapon involved, the stiletto, would be confiscated and condemned.
That's correct.
Okay, thank you. So Ms. Bowen, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Bowen, are you currently on any kind of probation or parole?
No.
Right. And you understand that by pleading guilty to count 1, which is possession of methamphetamine, that's a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine.
Yes, Your Honor.
And count 3, which is possession of methadone, that carries with it a maximum penalty of up to 2 years and or a $2,000 fine.
Yes, Your Honor.
With those maximum penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that we're making today. If you wanted to appeal it or try to reverse this plea, you'd have to ask the next higher court, which is the Court of Appeals, to hear your case. They could say no, and then that would be the end of that case. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
And are you pleading guilty because you are guilty of each of these charges?
Yes, Your Honor.
The date I have on the information here is October 19th of this year. Is that the correct date?
Yes, sir.
Okay. On that date, were you present here in Otsego County?
Yes.
And while you were present here in Otsego County on that day, did you have possession of some methamphetamine?
Yes, Your Honor.
Did you know that that's what that was?
Yes, Your Honor.
Did you have any legal right to have it at that time?
No, Your Honor.
And did you also have possession of some methadone?
Yes, Your Honor.
Did you know that that's what that substance was?
Yes, Your Honor.
Did you have any legal right to have that at that time?
No, Your Honor.
Thank you. Ms. Brucker, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Church.
We are satisfied.
Ms. Brucker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Church.
More of none, Your Honor.
Ms. Brucker, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Church.
Yes, Your Honor.
Ms. Bowen, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch with Mr. Trush so that you're ready to go forward on that day. And then before you leave today, you're going to meet with Ms. Davis from probation to set up a pre-sentence interview.
Okay.
That's all. Thank you.
Thank you, Your Honor.
See Mr. Pickett.
He is.
Yeah. Yeah, you wanna- Thank you.
Thank you.
Be something here.
I think so.
Mr. Pickett, if you want to come in, just have a seat at that table for right now. As soon as Ms. Davis comes back in, we'll go forward with your case. Okay, Mr. Pickett, you can come up to the podium, please. We're on the record in People versus Corey Pickett. This is case number 226401. The record should reflect that Mr. Pickett's present here in the courtroom today. Mr. Pickett, you're here for a show cause here that alleges that you violated your probation. And are you aware of what the alleged probation violations are?
For getting a new charge, getting a possession charge.
Right, exactly. It alleges that on or about June 29th of 2023, you were in possession of amphetamine in violation of condition 2.4, which prevents you from using or possessing any controlled substances, and that violation of condition 1, which is prevents you from violating any criminal law of the state of Michigan for the possession of that methamphetamine, and then also driving with a suspended license. So do you understand what the allegations are? Okay. I'm going to go through a few things with regard to your rights. You do have the right to have a hearing as to whether or not you did violate your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. If you are found guilty of any of those or of the technical violations, would this be a first technical violation, Ms. Davis?
I believe so.
Okay. So the maximum penalty you could face for those would be up to 5 days in jail. And then the non-technical violation, the maximum you could face would be the maximum underlying charge, which is up to 10 years. So do you understand all those things that I've stated to you?
Yes.
Okay. Did you want to request a court-appointed lawyer, or did you want to hire your own attorney?
I'm in the process of hiring one for the charge.
Okay.
I've been trying to get this taken care of since June, but it didn't come up till this November. It was a warrant out, so I mean, been in rehab. Pretty much got violated for this. At the same time, I failed my drug test. Told my PO about it. You know, I
don't want you to say too much because
Yeah.
anything you say right now could be used against you. So let's just, I don't want you to go into the details, but it sounds like you're hiring your own lawyer.
I'm working on it, yes.
You're working on it. Okay, so for now, the courts, I'm gonna enter a not guilty plea on your behalf. And we'll set this for a hearing at a later date so that you have an opportunity to talk to a lawyer. But again, if you determine that you're not able to afford one, the court can appoint one for you. So I just want to make sure you understand that, okay?
Okay.
All right. In terms of a bond pending that hearing, Ms. Davis.
Yes, Your Honor. Agent Vertical was going to ask for a PR bond so that he's been in compliance reporting And was also gonna ask that this be adjourned out, the hearing be adjourned out 60 to 90 days because of the new criminal that's pending.
Okay, so Mr. Pickett, we wouldn't set this for a hearing for a while to give you a chance to get those underlying charges resolved, okay?
Oh, so I got a whole new charge that I gotta go to court for, or?
No, just what you were talking about, what you're getting the lawyer for, those other matters.
Yeah, that's for the possession.
Right, yeah. So we wouldn't do anything with your probation until after that is taken care of.
Okay.
So the court will set this for a hearing in about 90 days. The court will set this as a personal recognizance bond, so you don't have to post any money. But you do have to make sure that you continue to comply with your probation in this case, okay?
Yes.
And that'll be a $500 PR bond, which again, you don't have to post that as long as you stay in compliance, okay?
Okay.
And Mr. Brunical is your probation agent, is that
Yes.
correct? Okay. Does he need to get in contact with Mr. Brunical
Yes.
today?
I've been talking to him. He said I have to go up there right after this.
Okay, good. All right. So just make sure you stay in touch with Mr. Brunical, and then we'll set this for a hearing in about 90 days or so. Okay.
Okay.
Did you have any questions about that at all?
No. Yeah.
Ms. Davis, anything further?
No, you're on.
Okay. All right, thank you. That's all for today, Mr. Pickett.
Thank you.
So I'm gonna track the those two.
All right, we'll set this matter, or I'm sorry. We'll be in recess until 4 o'clock. That's the next